Good morning.
Good morning.
Have you ever heard of the Central Labor Court from the media and wonder about its function and responsibility in our justice system? Or what should you do if you have to go to the Central Labor Court?
Today, it is a pleasure to provide you with the details. The Central Labor Court of Thailand was officially opened on the 23rd of April 1980. It is a specialized court established in order to settle labor disputes among employers, employees, and other parties involved. The main objective is to mediate the parties, to reach an agreement or a compromise in order to resolve the specific disagreements or disputes at hand. In case where parties could not reach a reconciliation, the court will proceed with the trial in accordance with the laws. The trial will proceed with the tri-party model, which the equal number of the professional judge and associate judges representing the employer and the employee shall constitute a quorum for adjudication.
The Central Labor Court is classified as a court of first instance under the Court of Justice. The court has territorial jurisdiction throughout Bangkok Metropolis, Samut Prakan, Samut Sakhon, Nakhon Pathom, Nonthaburi, and Pathum Thani provinces. We also have branch offices located in the above-mentioned provinces, in which the parties can file their complaints directly without going to the Central Labor.
According to Act on Establishment of Labor Courts and Labor Court Procedure 1979 and Rule of Labor Court concerning the proceeding in the Labor Court 2013, the procedure of the Central Labor Court has two salient features. First, the mediation process, which allows the case to be settled without trial. The case will be proceeded expediently and economically. Second, the tri-party model of the Central Labor Court includes associate judges representing both the employer and the employee who possesses proficient knowledge and acquire suitable experience in labor practice.
As Thailand is going to participate in ASEAN Economic Community, the Central Labor Court is ready for handling labor disputes relating foreigners who work in Thailand. We are capable of providing them with practical guidance and helpful service in order to ensure cost efficiency, convenience, expediency, and fairness.
What about the beginning of the process of litigation? If we have to go to the Central Labor Court, what are we supposed to do?
If the involved parties come to the court and require consultation or file a complaint, they can ask the public relations officers for consultation service. The officers will refer them to the legal officers for consultation, including drafting and preparing their complaints. Then, the involved parties must submit their complaints to the case filing unit or plaint receipt unit.
The process of litigation. 1. The plaintiff has to initially make a request for litigation at the section of legal officer. That's number 1. Subsequently, a legal officer would start giving advice to the plaintiff. The plaintiff must explain the facts in detail and show all supporting documents related to the case. This process should take approximately 45 minutes to complete, depending on the facts in each case.
2. The plaintiff may file a written complaint, petition, and witness lists accompanied by a copy of them with a section of complaint acceptance. After examining the accuracy of complaint and all documents, the officer may inform the date of hearing and mediation and give an appointment card to the plaintiff. When accepting the complaint for consideration, the court shall expediently fix the date of hearing and mediation and send a court summons, including a copy of the complaint to the defendant to appear before the court on a subsequent date.
When completing the process of filing the claimant, what shall we do next?
After filing the claimant, the process of mediation shall be launched. The section of mediation may arrange a mediator, a middleman who mediates the disputes among parties, together with a judge and a legal officer for assistance as well. In case where the parties could not reach a reconciliation, the court shall adjourn such case in order to settle the issue of the case and schedule the trial date again. How does the court trial proceed?
The court trial must be conducted in a courtroom by a judge, an associated judge representing employers' rights, and an associated judge representing employees' rights.
The process of litigation of the court. 1. Plaintiffs and defendants do not have to pay any court fees in labor court proceedings, such as filing, document sending, trial, and execution. In particular, the court shall pay witness fees and lodging house rent to witnesses who are called by the court. Two, case proceeding of the labor court shall be expedient. Therefore, plaintiffs and defendants should promptly prepare evidence, if any, and appear in court on every appointed date immediately.
Three, the court always attempts to mediate plaintiffs and defendants for agreement or compromise in order to provide both a better understanding without any losers or winners. Plaintiffs and defendants should understand and cooperate with the court's measures, so they have to abandon any intolerance and open up their mind to accept a reasonable offer of the other party or the court anytime.
Four, employers or employees are entitled to submit their cases to the court by filing a written complaint or by appearing in person to state the claims orally at the court.
Five, when the complaint accepted, the court shall order the parties to appear before the court on a subsequent date. Six, the defendant may file an answer before or on the date of hearing.
7. Both parties must appear on the date of hearing. When the plaintiff is in default of appearance, the court shall issue an order striking the case out of the case list. If the defendant is in default of appearance, court may proceed with the trial and adjudication of the case ex parte. On a hearing date, if both parties come to court, the court may reconcile the parties to bring about an agreement or compromise. If parties cannot come to an agreement, the judge shall settle the issues of the case, number of witnesses, and schedule the hearing date.
8. The hearing shall be proceeded continuously without delay. 9. When the hearing finished, the parties are entitled to close their case with an oral statement so as to conclude the significant facts or legal issues. A judgment shall be made in writing as soon as the hearing is over.
After the hearing process, the following steps are money receiving and appeal.
In case of appeal, the parties shall make an appeal to the Supreme Court within 15 days from the date the judgment is rendered. Only appeal based on question of law, for example, requesting the Supreme Court to look over any interpretation or application of law as any legal error occurred during the trial proceeding, is permitted. While question of fact, for example, seeking changes in the judgment by referring to any fact or evidence, is not permitted.
Judgment creditor shall contact court clerk for preparing a statement which will be submitted to the court for getting money rendered by the judgment. The judgment creditor then submits such statement to a financial unit. After granting by the court, a financial officer shall issue a check to a judgment creditor. If a judgment debtor does not deposit money with the court for payment of the debt according to the judgment, a judgment creditor may ask the court to enforce a judgment execution. For example, seize a judgment debtor's assets and sell in auction. If you have any question, please contact telephone number 02-235-150028.
It's not difficult, isn't it? You may gain knowledge about steps and procedure of how the labor case is processed. If you prepare and comply with this advice, I assure you that you will experience quick, convenience, cost efficiency, and fair trial.